Good morning, everybody. I'm Russell Rucker. I'm here for another constitutional talk. And today I'd like to get back to our Bill of Rights. And we've gone through the first three. Initially, we did the ninth. But today I'd like to get to talk about our rights of the accused, which basically means the Fourth through the Eighth Amendment. And yes, I'll take one at a time. Now, if you're pulled over by the police, there's certain rules that they have to contend with. If FBI knocks on your door, there's certain rules that any law enforcement agency has to follow. And the first thing that we need to talk about is our Fourth Amendment. And the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So, first of all, there has to be some kind of probable cause for arresting you or searching it. And here we have to do with searching. So, if they come up to your house without a warrant and they want to come into your home, they have to have a warrant. They can't just break down the door and barge in. They have to have a warrant that was signed by someone who had some kind of intimate knowledge with whatever violation you're being accused of. Generally, this means they already have to believe that you're guilty, and somebody has said, "Hey, I saw this or that, and I will sign," and it'll go to a judge, and a judge will determine whether to issue a warrant or not. Without a warrant, they don't have a right to search your property. Okay, and your person, whatever has to be on you, your house, your papers and effects, anything that's of a private nature of that type, they really have to have a warrant to get in to attempt to find you guilty of some kind of crime. And you have the right not to allow them in. You can let them in. You can invite them in. And if you think you haven't done anything wrong, well, maybe that's an avenue you want to go down. But you don't have to. Okay, so you have to have a person with intimate knowledge of what's occurred and ask for a warrant. It shall be issued by probable cause. And probable cause means they have a pretty good idea that you did whatever it is. In order to be pulled over, they have to have, even in a traffic stop, they have to have some kind of idea that, hey, there's something wrong. They have to have a probable cause to pull you over in the first place. They can't hold you longer than what is necessary in a normal stop. But the same goes in your home. If you're accused of something and they want to come into your home, there has to be some kind of search warrant sworn out. It has to be an oath. It has to be somebody saying, "I saw this" or "I know this." And a search warrant has to describe the places that will be searched and the things or persons that will be seized or taken for evidence. This is an important right of the accused, and it's one of the things that's often discussed in a courtroom, because it's whether or not the officer went through the proper procedure. And it used to be they had to give you a reading of the rights, but our Supreme Court has changed that a little bit. But always, in my view, it goes to the document. The Supreme Court is fine, and they make a ruling, and that ruling is how we have to operate. But when we're talking about theory of rights and what and how things are supposed to be, I don't go to the Supreme Court for that. I go to the document, I read it, and try to determine what really is what is intended for us. Now, when we were under British law, before we declared independence, they could come right barge in, search your home. There was always this idea that there was no innocence until proven guilty, that you were guilty until proven innocent. We're going to arrest you and let God sort it out later, that kind of thing. But our founders were tired of this arrangement, and they wanted some guarantees against that, because they wanted you to be able to be innocent until proven guilty. And that's what everyone is, no matter what you think and how much you dislike someone or something, they're still innocent until proven guilty in our way of jurisprudence. It doesn't mean they're innocent, but it means in the eyes of law. It's the idea of blind justice. And yes, those things, innocent until proven guilty, is not in our Constitution, and blind justice is not. But it's that basic concept of what we're talking about here. You know, as we get into some of the other amendments and the rights of a speedy trial and a jury of our peers and the right against self-incrimination, and we take all those things together, and it gives us an idea of how our justice system is supposed to work. Article 3 of our Constitution establishes a justice system. It establishes a Supreme Court and what they call inferior courts. And if you're charged with something, you have a right to have a fair trial, have a speedy trial. All these things matter. But when we're talking about the fourth, we're talking about the initial reaction and interaction that you have with law itself. And they have to be made to get a warrant. They have to have reasonable cause. There has to be a proper search and seizure. All these things matter because it comes into the process of what's going to occur. It doesn't mean you get away with a crime that you did. It just means that there are rules of engaging with the public, because it's the government. The government is not necessarily your friend. And sometimes you have to force the government to behave in a proper manner in order to get a fair trial, because to do otherwise would mean you would not have a fair trial. It can be difficult today trying to deal with the crime attitudes and the whole idea of what can occur in the streets. But at the same time, you have to have rules to govern the reaction and interaction you have with the police, because without it, it would be far worse. All of these rights, the rights of the accused, go back to how we were treated by the British and how our colonists had to deal with different issues. And always you're trying to go back and relitigate what's happened before you so that it doesn't happen again, which is the exact same reason why we study history. Is so in the study of history, we don't repeat the mistakes we've already made. I hope you think about this for a few minutes and get a good idea of the proper interaction with the police, with FBI, with whatever law enforcement there happens to be. And remember to protect yourself if it becomes necessary, in a legal manner, of course. So I hope today you understand what I'm getting at and what I'm talking about. And we'll talk again on the next Constitutional Talk. You have a great day. Goodbye.